only remedies the constitutional defect that exists by unfairly discriminating on the basis of gender, but accords more with the Constitution because it is inclusive of all identities. The applicants also sought an order, the first and second applicants also sought an order directing the first respondent to amend the surname of the first and second applicant's child to Jordan. This court finds that no case was made out in the High Court or in this court why this relief should be granted. The declaration of invalidity in this matter pertains to the violation of the right to equality on the ground of gender in the specific context of marriage. It cannot follow as a matter of course from this declaration of invalidity that a child whose surname is determined under a different provision of the Act may have their surname changed following such declaration. Accordingly, the first and second applicants will be entitled to apply to the Director General to change their child's surname as provided for under Section 25(2) of the Act. In respect of cost, this court finds that it is appropriate for a cost order to be awarded against the first respondent, despite the fact that they did not oppose the confirmation on its merits. This is because, but for the constitutionally defective provisions, the applicants would not have had to bring this litigation to vindicate their constitutional rights. The court makes the following order. 1. The order of constitutional invalidity issued by the High Court of South Africa, Free State Division, Bloemfontein, is confirmed. 2. Section 26(1)(a) to C of the Births and Deaths Registration Act 51 of 1992 is declared unconstitutional to the extent that, in violation of Section 9(1) of the Constitution, it violates irrationally on the ground of gender, and to the extent that, in violation of Section 9(3) of the Constitution, it unfairly discriminates on the ground of gender by failing to afford a woman the right to have her spouse assume her surname, failing to afford a man the right to assume the surname of the woman after marriage, failing to allow for a married or divorced man or widower to resume a surname which he bore at any time, and failing to allow a man, whether married or divorced, or a widower, to add to the surname which he assumed after the marriage any surname which he bore at any prior time. 3. The declaration of invalidity is suspended for a period of 24 months to enable Parliament to remedy the defects by either amending the existing legislation or passing new legislation in order to ensure that all persons are afforded the right of assumption of another surname. Pending the coming into force of the new legislation or amendments to existing legislation designed to afford the right of assumption of another surname as set out in Section 26(1) of the Act, it is declared that the provisions of Section 26(1) shall not apply when a person after marriage assumes the surname of the spouse with whom such person concluded a marriage, or after having assumed such surname, resumes a surname which they bore at any prior time. B, a married or divorced person, or a widow or widower resumes a surname which they bore at any other time. And C, a person, whether married or divorced, or a widow or widower, adds to the surname which they assumed after the marriage any surname which they bore at any prior time. 5, should Parliament fail to correct the defects in the 24-month period, paragraph 4 of this order shall continue to operate until remedial legislation, if any, is brought into operation. 6, the first respondent is ordered to pay the applicant's costs in this court, including the costs of 2 counsel where so employed. I hand down the judgment. Ms. Swart, this is where you say, as the court pleases. Court will rise.